Thank you. Welcome. I'm Bronwyn Naylor. I'm the Acting Director of the Castan Centre, and I'd like to acknowledge the people of the Kulin Nations on whose land we're gathered today, and to pay my respects to Elders past and present. As many of you would know, the Castan Centre is a research centre based in the law faculty at Monash University, and our aim is to improve human rights through policy, public education and student programs. And through our policy work in particular, we've seen up close the vital role that the Australian Human Rights Commission plays in holding governments to account and in leading conversations about human rights obligations, both here and around the world. So we're delighted to host Australia's new Human Rights Commissioner, Ed Santow, for this year's King and Wood Mallison Castan Centre Annual Lecture. And I particularly want to thank King and Wood Mallisons for hosting the event, as it has every year for the past decade. And I'd like to now introduce Ben Keeley, who's a Senior Associate at King and Wood Mallisons, and who will introduce Ed Santow. Thank you.
Thanks very much, Bronwyn, for that very kind introduction. Ladies and gentlemen, it is a great pleasure to see you all here today, and on behalf of the partners of King and Wood Mallisons, it's my great pleasure to welcome you to what will promise to be a very interesting and informative lecture with Ed Santow, Australia's new Human Rights Commissioner. Mallisons is proud to sponsor today's lecture and to have done so for the past 10 or so years. We've jointly been presenting this annual lecture on topical human rights issues presented by leading figures who can share their latest thinking on human rights issues that are relevant to Australia and the world, and today's lecture promises to be no different from that past tradition. For those of you that aren't Mallisons, and I can see a few familiar faces here today, you may be aware that Mallisons is a top 10 global firm with almost 600 partners, over 3,000 lawyers, and a total of 4,500 staff in over 30 offices around the world. We're the only law firm that's able to practice Chinese, Hong Kong, Australian, English and US law locally. We open doors and unlock opportunities for clients as they seek to work in the Asian century. In Australia, through our community program, we have a strong commitment to human rights. We're the only law firm in Australia with a dedicated human rights law group. This group allows our partners and lawyers to apply their market-leading insights to assist our commercial clients with human rights issues that they face in the course of their business, but also our pro bono and community partners to access justice they may otherwise be denied. In the last financial year, in Melbourne alone, King and Wood Mallisons lawyers donated the equivalent of over $4.5 million worth of legal services to assist those in need. As mentioned, our speaker today is Ed Santow, Australia's newly appointed Human Rights Commissioner. Ed mentioned that he's got a set of estimates coming up in a short time, and he's only been in the chair for a short period of time, so we're hopeful that those estimates won't be too taxing or controversial for him. So hopefully he won't say anything today that causes a stir at his upcoming appearance or cross-examination before the Senate. As mentioned, Ed's only recently started at the Commission. He was appointed as the Human Rights Commissioner in August 2016. Before that, he spent 6 years leading the Public Interest Advocacy Centre, a strategic, non-profit law and policy organisation that assists vulnerable Australians. Ed has a particular expertise in human rights, administrative and constitutional law, discrimination and freedom of information. He's also a Mallisons alumni, but don't hold that against him. As Human Rights Commissioner, Ed's role is to promote human rights by operating at the intersection between government, business and civil society. The focus of Ed's work is to protect the long-standing human rights recognised at the common law and also at international law. These include equality, freedom of expression and association, and procedural fairness. Separately to his work at the Commission, Ed is also Senior Visiting Fellow at the University of New South Wales and serves on a number of boards and committees, including the Australian Pro Bono Centre. The topic of Ed's speech today is peering through human rights tinted glasses. For those of you that feel the need to have such glasses on for this lecture, if you reach under the seat, they'll be available in appropriate shades of rose as required. By considering pressing social issues, such as the proposal for marriage equality, the treatment of people in detention, and the debate on free speech, Ed will today explore with us the role that international human rights law has to play in helping us think about and potentially resolve some of these pressing social issues. He'll ask the important question of whether human rights law provides a comprehensive answer to these issues, or instead perhaps a path to thinking about the answers themselves. Promises to be a fascinating and, given the nature of the issues that our society faces, a very timely address. So would you please join me in warmly welcoming Australia's new Human Rights Commissioner, Ed Santow.
Thank you very much, Ben, for that incredibly warm welcome. And I'm very grateful to you and to King & Wood Mallesons for making this event possible. I also thank the Castan Centre and Monash University, represented by the Vice-Chancellor, for inviting me to speak. It is a great honour to be here. If I can pause very briefly to acknowledge some of the wonderful people and work from the Castan Centre, because it's been hugely influential on me, and I've learned a great deal from people such as Bronwyn Naylor, who you spoke before, who you heard from before, as well as Azadeh Dastiari, Julie Debblejack, Melissa Castan, Paula Gerber, and Patrick Emerton. As a human rights lawyer, it's poignant for me whenever I acknowledge country, the fact that we are meeting on the Wurundjeri people of the Kulin Nation. It's especially poignant because we're meeting on Wurundjeri land, but the land is no longer occupied by the Wurundjeri people, and in that acknowledgement is bound up almost 2.5 centuries of occupation of Australia, and much injustice that has flowed from that. I'm going to be talking today about peering through human rights tinted lenses, and I'm going to warn you that I'm going to start with some extended musings on a quite different topic. While I'm undertaking those musings, I would encourage you to think about some questions that you may wish to ask me, because it may not be for everyone. This year we celebrate, or depending on your perspective, we mourn the 60th anniversary of the first computer to defeat a human at chess. It occurred, predictably enough, in Los Alamos, and the human was a novice. Over the next 30 years, the best humans easily saw off the best computers. But by the late 90s, the tide had well and truly turned, epitomised by Deep Blue's famous victory over Garry Kasparov. In 1987, someone by the name of Hikaru Nakamura was born in Japan, and then very soon after that, he and his family moved to the US. When he was 15, under the tutelage of his chess-obsessed stepfather, he became the youngest ever grandmaster. In 2008, Hikaru took on Ribka, which is generally regarded as the best commercially available computer chess program. By that time, flesh and blood chess players, even grandmasters, rarely beat the best computers. But Hikaru figured out a way to exploit hitherto unexplored weakness in the computer's programming. He started by following a well-worn series of moves that almost always ended in a stalemate. But then, at the last moment, he did something unexpected and brilliant. Having seized the advantage, Hikaru didn't take the swiftest route to victory. Instead, by advancing slowly up the chessboard, he contrived to convert all of his 6 surviving pawns into bishops. His end game was pure human flamboyance. He encircled Ribka's king with an unholy collection of bishops. That passes for a joke in the chess world, by the way. Now, I like this story for a lot of reasons. The first is it contains the 3 subjects that make up the nerd's trifecta: child prodigy, chess, and computer. Secondly, in the battle between human and machine, the human won. I take to heart the increasingly alarming stories of machines turning against their masters, so much so that this morning I was looking cockeyed at the toaster. So it's nice to see Hikaru getting one back for the humanoids. Thirdly, and more seriously, it suggests to me a useful conceit from my perspective on international human rights law and the role it can play in a jurisdiction like Australia. I realise that I'm drawing a really, really long bow here, so please bear with me. The Human Rights Commission, and my own role as Commissioner specifically, is grounded in international human rights law. The Commission's jurisdiction, its powers and its authority derive their substantive content as well as their shape from international human rights law. Our remit doesn't quite spread across all international human rights law, but the starting point is the 5 international instruments, including the ICCPR, that are scheduled to the Commission's constituting statute. By grounding our work in international human rights law, we're doing something really important. Not only does it mark out territory over which the Commission claims authority, it provides what I might call the intellectual ballast that supports the Commission's contribution to debates that are often highly contested. The alternative is that the Commission becomes a commentator who insists you listen to them solely because they have a megaphone and a really loud voice. In other words, giving our tuppence worth on important issues, but without institutional expertise and experience that comes from a great history of work in human rights, it risks diluting the Commission's voice and ultimately our impact. So the corollary of relying on our intellectual ballast is that there are some waters where the Commission's ship is ill-equipped to sail. For example, Commission staff like me might have really strong personal views about issues like the funding of political parties. But when we're speaking with an institutional voice, we can only approach this from, I guess, a narrower human rights perspective. There might be very persuasive arguments in favour of, say, restricting political donations from property developers, but we at the Commission need to stick to the human rights arguments. We've got less competence on the other dimensions of the issue, such as the economic cost-benefit analysis, or whether there's likely to be a differential impact on parties of the left or parties of the right with such a reform. By showing some restraint, it's difficult. It probably goes against our nature from time to time, and it'll also mean sometimes giving up an opportunity to make an important point. But I think that restraint is really vital in preserving and building the respect for the Commission's distinct and important role in public policy. So whenever we at the Commission look at a social issue, our starting point is to ask the question, how does international human rights law help us to resolve that problem? Perhaps I can return now to my earlier computer chess conceit in unpicking our process a bit. Early computers could really only cope with problems that had a single correct answer. A pocket calculator is a good example because it's very good at making calculations, even really complicated ones, because those calculations involve the application of an ironclad rule with a single correct answer. It would be handy if international human rights law lent itself to that sort of approach to problem solving. I kind of have in my imagination, you put in the variables and then there's a big international human rights law answer generator that spits out a result, lawful or unlawful. There certainly are some areas where the law is almost that black and white, but that's largely limited to absolute rights. For example, slavery isn't permitted in any circumstances, no ifs, no buts, or possibility of compromise. The only grey area really relates to factual questions, not the law. For instance, whether the person accused of slavery actually committed the acts that constitute slavery. It's inconvenient, but unfortunately true, that those black and white areas are pretty rare. More often, international human rights law provides a guide in how we should accommodate competing rights and interests. It reflects that because humans are social animals, what we do generally causes us to interact, and as soon as we interact, we need to find ways to compromise so that our interactions don't impinge more than is absolutely necessary on the basic dignity of those around us. So in human rights law, the main mechanisms for achieving that compromise are the process of derogation and the construction of lawful limitations on human rights. The big question is, how do we activate those mechanisms? Especially given those mechanisms need to operate in a way that is on one hand predictable and consistent, and on the other hand nuanced and adapted to the particular circumstances at hand. So whereas a computer type approach is good at predictability and consistency, it fails in human rights as well as some other complex areas of law and social policy. Let me try to explain. So the computer has improved at chess over the last 60 years because its processing power has been on the up and up. So through brute processing force, it has become better at conceiving of the many scenarios that might arise from different moves and counter moves, and based on the strict and simple rules of the chess game, it can assess the relative merits of any particular option. In other words, the computer plays chess with none of the creativity or the intuition that is central to the human grandmaster's genius. But the computer's approach works. That is, it works until a novel or unpredictable scenario arises, as Hikaru showed. And that's precisely the problem with social issues and human rights. A computer type approach, that is a regimented or a mechanistic type approach, doesn't work in human rights, and there are three main reasons. The first is that human rights generally offers no single simple rule to apply, and so as a result there's rarely a single correct answer. So even with huge processing power, imagining a vast number of scenarios, that's still inadequate. If you take, for example, the current debate about religious exceptions to the proposal to permit marriage equality or same-sex marriage, we have to ask the question, where should the line be drawn? Should people be permitted not to solemnise a marriage because of their religious convictions? Or should that exception be extended to people who provide services at a marriage reception? Where does the line get drawn? And the line can only be drawn by careful, nuanced consideration of impact on the actual people affected. Secondly, unlike chess, the broader rules of human interaction are neither strict nor straightforward. They're messy. They're messy and they're complex, and they're an amalgam of formal and informal laws, policies, practices and norms. Those rules are not all internally consistent, nor are they applied evenly or predictably. But we have to take note of those rules in devising practical and effective strategies to protect human rights. The third problem is that chess is zero-sum. The end game is to defeat your opponent. By contrast, human rights as a body of law, principle, philosophy, as a way of seeing things, aims to protect individual dignity, but in a collective way. That is, it aims to protect the dignity of all individuals. So to try and put that more positively, a human rights approach frequently demands a process of accommodation and compromise that is more art than science. It draws on skills that are innately human. Take, for example, the role of the proportionality principle. That principle, which has been around in law going back to the 19th century in Prussia for many years, has been central in adapting human rights law from incontrovertible but abstract concepts so that they can apply in a really practical way to the pressing social problems that we face. As many of you would be aware, a proportionality analysis starts with a human right that is being impinged and asks whether that impingement has a legitimate aim. We then consider whether the means used to achieve that aim are appropriate and necessary. In essence, proportionality allows us to compare apples and oranges. To take an example, the right to freedom of expression comes into friction with a government's aim to protect intellectual property, like copyright. They are apples and oranges, that is, freedom of expression and intellectual property, because free speech and IP drive at completely different goals. Proportionality enables each to exist without impinging more than is necessary on a shared goal of individual dignity. Perhaps a more topical example would be the restrictions that exist on racist or homophobic vilification. An anti-vilification law presents even more difficult questions because it involves a tension between two human rights, as distinct from a tension between a human right and another interest that doesn't quite rise to the level of human right. So where does that leave us? For me, it means acknowledging three features of peering through human rights tinted glasses. The first is that it's really hard, or it can be really hard. The second is that it's rarely a search for a single correct answer. Rather, it's more commonly a search for practical compromise that places the protection of individual dignity at the very centre. And the third is that it isn't susceptible to a mechanistic or computer-like approach. Instead, it requires us to get our hands dirty, dealing with the complexity of human relations. So before I move to a few practical areas, I want to make one further point. While I think acknowledging these things is important, I'm not in any way saying that a human rights approach, or for that matter, international human rights law more generally, is a pathway towards arbitrary decision making or even a fig leaf for being guided just by your own instincts. On the contrary, I think by acknowledging the difficulties that I think are inherent in this area and being disciplined in adopting an approach that mitigates any resultant problems, we're more likely to bring human rights to the forefront of how we deal with social problems in Australia, especially given the absence of a statutory or constitutional Bill of Rights at the national level. So far, I've been speaking in fairly theoretical terms, and perhaps inexplicably, I've been referring repeatedly to chess and computers. I'm now going to try and speak a bit more practically, and there'll be no more chess or computer references. So I've been in my role now for 2 months, and for my first year, I'll have three main focus areas as well as some other small focus areas. First is marriage equality and other LGBTI rights issues. The second is conditions of detention, and the third is freedom of expression and some other related rights. So I'll talk about some of these issues, but I'm really happy to take questions or comments on any of those areas. So starting with marriage equality, I'm acutely aware that I go through the world without the lived experience of a person from within the LGBTI community. I care deeply, both personally and professionally, about the issues, but I know that the absence of direct experience on my part means that I'm entering a really febrile debate on marriage equality as well as other less prominent but equally important LGBTI issues. I'm entering those debates with greater capacity to make mistakes. Please tell me when I do, especially if you have direct lived experience of the issues I'm given the privilege to talk publicly about. So marriage equality. Marriage equality is an issue where international human rights law provides guidance as distinct from a clear-cut binary answer. At the Commission, we've reflected in particular on Article 26 of the International Covenant on Civil and Political Rights. That is the article that deals with equality before the law. Now, there are some interpretations of Article 26 and other provisions in international human rights treaties that don't go so far as to protect marriage equality. The 1999 opinion from the UN Human Rights Committee in the New Zealand Jocelyn case is most often cited to that effect. However, if you look at the issue globally, those sorts of opinions are increasingly being confined to a historical minority. Instead, there's a broad emerging consensus from respected and authoritative international bodies, as well as courts in comparable jurisdictions to Australia, that the principle of equality before the law and non-discrimination demand that marriage be extended beyond heterosexual couples. And that is the Commission's position. At the same time, a human rights-based approach requires us to consider whether legal recognition of marriage equality involves an impingement on other human rights. And the most obvious impingement would be freedom of religion. Some, but of course not all, religious organisations see marriage equality as contrary to their core religious beliefs. So if we accept that, then what we need to do is carve out a space to ensure that members of those religious organisations can continue to practice their religion without more than necessary interference. So for that reason, the Commission endorses what is a very widely accepted view that religious organisations that object to marriage equality on religious grounds should not be required to, technical word is solemnise, same-sex marriage. And indeed that's reflected in our current Marriage Act. It's necessarily a compromise. And as with any compromise, it involves some give from each side, but crucially what it aims to do is to preserve the dignity of all the people that are most affected to the maximum extent possible. So that's our position on the substantive issue. We're also conscious that we're in the middle of a really vigorous debate about this reform and more acutely how that reform should be formally considered. Now, whether that should be resolved by plebiscite is ultimately a question for Parliament. But from a human rights perspective, where the Commission don't believe that a plebiscite is appropriate at all in resolving an issue of fundamental human rights. So as the public debate intensifies, we see the Commission as having two key roles in relation to marriage equality. First, there's an important role, but it's perhaps not going to be a hugely visible one, for the Commission in promoting, I guess, a more respectful debate on this issue, especially a public debate. So whether or not the plebiscite goes ahead, there's a national debate happening anyway. The evidence is fairly clear that there is serious risk of harm, particularly to young LGBTI people. So the question is, how can we mitigate some of that harm? It doesn't mean transforming a fairly bruising debate into a kind of a calm intellectual salon. That's just not possible. But can we mitigate some of that harm? So, speaking in a practical way, in the discussions that I've had with both of the main sets of advocates, they've set out some of the things that would help. So many opponents of marriage equality object to the use of labels like homophobe and bigot being used against anyone who is sincerely and conscientiously and carefully advocating that the Marriage Act not be changed. On the other side of the debate, advocates of marriage equality don't wish the debate to be portrayed as something that it's not, such as a referendum on rainbow families or a referendum on the Safe Schools program or anything like that. It should be confined to what the actual change will bring about. The second role for the Commission in the debate is providing simple, clear community education about the human rights issues that relate to marriage equality. That can be done in a way that breaks down some of the myths, that makes it clear what the debate is really about, and that shows how an accommodation of competing rights and interests can be done. In addition to marriage equality, over the coming year, the Commission will promote the rights of intersex people by building on the findings of the inquiry from 2013 in the Senate on involuntary or coerced sterilisation of intersex people. This is an entirely new area to me, and the more I've been looking at it, the more I've been horrified at what is currently taking place, and the really unsophisticated way in which particularly young intersex people are treated medically. So the Commission will focus on evaluating the current approaches taken to medical interventions in Australia and other jurisdictions, referring to a human rights-based framework. And we'll also be developing a nationally consistent human rights-based approach to how decisions about medical interventions with the aim are made, with the aim of ending medically unnecessary, non-consensual, so-called normalising interventions. As Commissioner, I'll be taking the lead on our marriage equality and intersex rights work, but the Commission as a whole will continue doing really important work in a range of other LGBTI rights issues. For example, my colleague Megan Mitchell, the Children's Commissioner, is leading the Commission's advocacy to amend the Family Law Act, which would enable trans young people to access what is called stage 2 treatment without the really cumbersome need for a court order. And Kate Jenkins, the Sex Discrimination Commissioner, leads the Commission's work with the Sports Commission and Pride in Sport to promote trans, gender diverse and intersex people being included properly in sport. Now, before I run out of time, I want to make brief mention of another major area that I'll focus on in my first year, and that's it's a very cumbersome title, the optional protocol to the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment. It's generally known as OPCAT, which saves that big mouthful. Many of you, I know, particularly at the Castan Centre, are experts, world-leading experts on OPCAT. But for those of you who are not, Australia has been a party to the Convention Against Torture, known as CAT, for more than a quarter of a century. OPCAT is a really interesting additional treaty, related treaty. It came into being in 1987. Interestingly, it doesn't create any new rights beyond those already set out in CAT, which is the main treaty. Instead, what it's intended to do is create a kind of a procedural mechanism that holds states to account for their obligations under the Convention Against Torture. So Australia signed OPCAT in May 2009, but we haven't yet taken the final steps that would make it operational in Australia. And those are ratifying the treaty and then implementing it into our domestic law. What that would do in practical terms is it would lead to Australia establishing what is known as a national preventative mechanism or mechanisms. Essentially what that would look like is it would be a network of independent Australian, not international, but Australian monitoring bodies that proactively go into places of detention to identify practices that could be in breach of the rights set out in the Convention Against Torture. And then the National Preventative Mechanism would work with those authorities and the relevant Australian governments to fix those problems before they get to grotesque. The other element is that it would enable the UN to send a monitoring team to Australia probably once every 5 or 10 years. So I'm sure everybody in this room saw the horrifying images from the Dondale Youth Detention Centre that were broadcast on Four Corners a couple of months ago. They exemplified the need for more to be done to protect the basic rights of Australia's most vulnerable detainees. In an OPCAT jurisdiction, what happens is that some of the worst practices are likely to be identified at a relatively early stage, in other words, before they metastasize. So, to take that example, an OPCAT monitoring body would identify the problems with the use of so-called spit hoods on young people who are being detained. That would lead to a conversation with the detention authority that would show that while there may well have been an understandable or even legitimate aim behind that practice, and that was to stop the spread of disease, there are in fact many alternative solutions to that disease problem that would not have been so damaging to the basic rights of the young people involved. So we at the Commission are advising the federal government primarily, as well as the states and territories, on OPCAT, what it will mean, busting some of the myths as well. And we're hopeful that the government will soon announce how it's going to proceed. So, to return to my title, we at the Commission do peer through human rights tinted glasses. That means grounding our work in international human rights law, and that's because that's where our expertise and experience lie. It also means seeing human rights law for what it is, namely a set of legal principles that promote practical compromise between competing rights as well as competing rights and interests. And the ultimate focus is on protecting individual dignity. And we acknowledge, indeed we embrace the fact that this is a messy human endeavour. And so for that reason, we strive to be more like Hikaru Nakamura rather than his computer nemesis, Rivka. Yeah.
Thank you so much, Ed. I think we've got a little bit of time for questions from the floor, and I think, Janice, you have a mic. Caitlin has a mic. Thanks, Paula. Thank you.
No, right?
Thanks, Ed. Great speech, and obviously your audience is very receptive to the idea of looking at social issues through human rights tinted glasses. But how do you get others to put on those glasses? And in particular, I'm thinking about the whole debate we saw about the Safe Schools Coalition. To me, that was fundamentally an issue about children's rights, but not once did I hear anybody participating in that debate talking about it as a human rights or a children's rights issues. Asylum seekers are the same. The debate is framed in terms of border protection and security, not human rights. So how do you get our politicians in particular to put on the human rights tinted glasses?
So a really good question and not an easy one. My first couple of months, I've largely been on receive rather than transmit. I've been listening to people, especially stakeholders who feel really strongly on these issues. So taking your first example in the LGBTI space, there is kind of a distressing conflict often between what might be described as human rights organisations and religious organisations. And it's partly distressing because that conflict that plays out in the LGBTI space, but also plays out in some other spaces as well, is new, right? Like if we go back just sort of 20 or so years, it would not be, there certainly wasn't that conflict between those two kind of sectors within our community. In fact, religious organisations and human rights organisations were often the same organisations. So that kind of fracturing is really, really distressing, as I said. I think part of the answer there is to listen to each other a bit better. And I think in my previous role at PAC, I didn't do a particularly good job of that. So listening to some of the religious organisations that I've been speaking to over the last couple of months, one of the really interesting points that keeps on coming up is that they want to be treated respectfully by human rights organisations, and they are interested in finding areas of common cause. I know that I'm about to say a cliche, so I'm just going to go in and embrace it. There are, I think, more things that unite us than divide us, particularly in the human rights area, and particularly when talking with people of faith. So I think part of the issue is to find those areas where we have common cause. And I think refugee law is perhaps an area where there's some good prospects for that, and build trust in that way. And by building trust, I think it has the potential to make both sides feel more comfortable in each other's company. and comfortable in understanding where the other side is coming from. Now, I guess what I'm advocating there is hard, patient work. It's not sexy. It's time-consuming, but I think it's really, really important. I think the opposite is really dangerous, a further fracturing of those sorts of communities, people who are guided in their actions by principle and faith and by high principle in terms of human rights as well. I think is really damaging for us as a country.
Thank you for your speech. Something that I come across in discussions quite regularly is the ranking of human rights, particularly of civil and political rights over social and economic and cultural rights. How do you respond to that kind of approach?
Yeah, it's something that some countries do more than others, and we seem to do it more in Australia than a lot of other jurisdictions, and it's not something that comes from international human rights law. In fact, indivisibility of human rights and the interrelated nature of them is really, really central. There's a whole bunch of accidents of history. So the ICCPR, as I mentioned, is scheduled to the Human Rights Commission Act, but the ISESCA is not, the International Covenant on Economic, Social and Cultural Rights. And so that gives us authority to speak about ICCPR rights but not ISESCA rights, or at least that's how some interpret our mandate. But I think it's unhelpful. I think what happens a bit under the Victorian Charter, which is more about civil and political rights, is quite helpful, because you see arguments being made, not just in court, more generally, about how rights like the right to life do extend into territory that might be seen as socioeconomic rights. So I think breaking down some of those barriers, but in a practical way, through conversations and through an understanding of how, in practical problems, those rights are not completely separable, is probably the way to do it.
Thank you. Do we have another question? Can I just jump in?
Sure.
As a sort of making use of my position here.
Did you want to?
No, it was just that you mentioned that you had 3 priorities in having been in your position now for a couple of months, and did get to your 3rd one.
Yeah, freedom of expression.
Yes.
This is a tricky one, isn't it? So I'm sure everybody in the room is well aware of the debate that keeps on flaring up and has been flaring up for a number of years now about Section 18C of the Racial Discrimination Act. It's sometimes referred to as the racial hatred, one of the racial hatred provisions in the Racial Discrimination Act. I don't have primary responsibility for that work. My wonderful colleague Tim Soutphommasane, the Race Discrimination Commissioner, speaks for the Commission on that, but his position is exactly the same as mine. We're all of one voice. It's a really, really important provision, particularly when coupled with Section 18D, which provides some really important free speech protection. I guess my concern is that all of the sound and fury about 18C means that we're not talking about some of the other very important restrictions on free speech in a country like Australia. So, to give an example, there's a case going to the High Court very soon on the Border Force Act. So some of you may be aware that the Border Force Act includes a provision that would restrict people like doctors who go into immigration detention centres from speaking publicly about what they've seen there, even if they've seen very horrifying things that are in breach of human rights. Now, there are some free speech protections written into the legislation, but they would be really hard to activate, and so there's unquestionably a chilling effect on free speech by a provision like that. I guess what I'm going to be trying to do is find ways to take at face value what some of the opponents of 18C are saying, which is that what they're really concerned about is free speech more generally, not just free speech in the context of racial hatred or racial vilification, but free speech in all of its contexts. So, assuming that's the case, and I've got no reason to doubt it, then I think we can perhaps turn what has become a fairly toxic debate and a stalemate, to use the chess analogy again, into a lever to perhaps get some really important change to protect free speech in a range of other areas that are actually making a very significant and negative human rights impact.
We have time for one more question. Thank you.
So I'm from the United States, and one of the fallouts that we've seen after the Supreme Court decision for granting LGBT individuals the right to marry is how you define religious organization, and whether or not you take the broader view and allow discrimination in society, like a baker not baking a cake or whatever. So I was wondering if you had a perspective of how you actually go about defining what is and what is not a religious organization.
Yeah, that's a really good question, a really tricky one. And perhaps there's sort of maybe even two questions in there that we should try and sort of separate out. The first is, what constitutes a religious organisation? Interestingly, we've got some old but fairly solid case law on that in Australia, which takes a fairly broad view. It was a case about the Church of Scientology. Takes a fairly broad view about what constitutes a religious organisation. Australia has a long history of not taking some things too seriously, so there are a large number of people in the census before last who said that their religion was, I think, Jedi Knight. It probably wouldn't extend that far, but certainly a fairly broad view on religion, I think, is important and appropriate. The second question, which is bound up in that, is what are the circumstances in which you can kind of take advantage of an exception to an anti-discrimination provision? And so that's certainly raised front and centre in relation to marriage equality. Where the Commission would say you have to draw a line between a religious organisation saying it's contrary to our faith to solemnise, in other words, to marry two people of the same gender. But that's quite different from a butcher, baker or candlestick maker saying, I'm not going to offer a service paid or otherwise to a couple because they're not heterosexual. Now, the line that you draw between those things, I guess, is, a perfect example of one where we say, look, we're applying principles really carefully here. It's certainly not an arbitrary line at all, but it is also a judgment. And it's a judgment, I guess, that can't be simply done mechanistically. It's one where you're trying to weigh up two things and work out how to create the right compromise. So that's the position that we've put to the government on this, and I think the bill that the government is likely to settle on will probably have that accommodation, but it remains to be seen.
Hi, Ed. If you go back, certainly to say the 90s and perhaps pre-96 might be a date, Australia not only had a very good relationship with the United Nations, but it had a good view of the United Nations in terms of our media and the public in general. And I think there's no question that that's deteriorated significantly since that time. Do you see the Commission as having a role in trying to improve not only relations with the United Nations, but the public's and the media's perception of the UN as an institution?
Certainly the human rights elements to it. I mean, I think it goes both ways. I think the Commission as a national human rights institution has a really important role in contributing to the UN's own processes. And really the UN, as much as anything else, is the kind of combination of our collective goodwill. And so where a country criticises the UN, it's partly, I think, should be interpreted as a bit of a self-criticism, because it usually means, not always, but it usually means that they've walked back from that kind of common effort. So that's a really important thing. I think we can certainly break down some of the myths about what the UN does and doesn't do, and OPCAT is a really good example. One of their kind of, really difficult to shift myths is that by signing OPCAT, what it really means is that there'll be UN inspectors coming into every place of detention in Australia all the time. Whether or not that's a good idea, it just won't happen. What's most likely is, as I said before, every 5, probably more likely every 10 years, a committee known as the SPT will visit Australia and will visit a very small number of places of detention, so it gets a bit of a sense, so it can make comparisons across different countries. So I guess, the myth that really plays to is the notion that the UN is really this big overarching government that reduces to almost nothing the sovereignty of individual countries, and it's just not true. And we can certainly speak publicly and do speak publicly to break down that myth. But I actually think a bigger contribution is by contributing and encouraging other parts of government and civil society to contribute really positively and constructively to make the UN a better body. And there's no question that it's imperfect, but the alternative, I think, is far worse. The alternative of living in a world without the United Nations is much, much worse. Thank you.
Okay.
Great.
Thank you very much. So that's all we've got time for today. But before we conclude, I would just like to mention that the Castan Centre has an event next week with Kabu Okai-Davies, who'll be speaking about literacy and human rights, and that's on the 12th of October at the Monash University Law Chambers in Lonsdale Street. So at that point, I'd just like to thank you all again for coming today, and could you please join me in thanking Ed Santow.